Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program's been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. In each segment, we continue to provide information and resources to help you decide whether you need or want to contact a lawyer. You may, in fact, decide that you can handle some issues yourself. If you do decide to retain outside counsel, you'll be better prepared, and so will the counsel you select. Of course, that's our goal always. We would like for you to be able to achieve the best possible results while saving time and money. The Bizarre & Associates law firm in East Providence continues to help us in each of the topics we discuss, weighing in on the legal facts that affect your life, as well as some interesting anecdotes, as always. So once again, we would like to welcome and thank Attorney David Bizarre. So today's topic is mediation, also referred to as one of the techniques of alternative dispute resolution, ADR. At times, litigation can be avoided. It's expensive, it's cumbersome, it's emotionally draining, aggravating, unpredictable. So you, of course, can never be certain of the outcome until the judge or the jury decides a case. And because it can be a little bit inefficient and sometimes cumbersome, it makes sense that alternative dispute resolution has become increasingly popular. Today we'll discuss mediation and arbitration, how and when does it work, and what you need to know. I guess everyone's looking for a kumbaya moment when we can move away from confrontation to more common grounds. That's good, and probably even better if you can find a win-win. So David, let's start with the definition of the terms and the differences between mediation and arbitration.
Sure.
Take it away.
Okay. So as you said, they're both forms of alternative dispute resolution. Mediation is a process whereby you select two parties. When I say you, if it's a case that's in suit, a plaintiff and a defendant, their attorneys select a neutral mediator, and the mediator is tasked with trying to bring the parties together. So a mediation, it's not a trial. It's a negotiation or a settlement negotiation where each side presents their case or facts to the mediator, and then the mediator goes back and forth with the parties to try to come to a resolution that the parties agree to, not that the mediator sets. As opposed to an arbitration, which is sort of like a mini trial. Both parties select an arbitrator. Now, there are different forms of arbitration, but in general, if it's a one-panel or one-person arbitrator, they agree upon the arbitrator. They then present their case to the arbitrator through an informal trial, so to speak, and then the arbitrator writes a decision based upon the facts and evidence that he heard from the parties.
So when it comes to mediation, that's usually when there's only one person that's needed to be the pivotal point, or the one who's presenting alternative sides or discussing things, correct?
Well, yes, there's usually just one mediator. There can be situations where there's complex mediation where there may be more involved, but usually it's one mediator. And the mediator isn't deciding the facts, the mediator isn't deciding the resolution, the mediator is just trying to bring the parties together. So oftentimes, take divorce mediation, for example. Both parties will come to the mediator, and the mediator will explain that I'm not here to tell you what the law is, I'm not here to tell you what facts are better under the law, I'm here to help the two of you come to a resolution. And the resolution may or may not be what a court would decide. And oftentimes the parties don't want what a court would decide. They want what's going to work best for them. And so the mediator is there to help them come to those terms that are going to help resolve their dispute best for their situation.
So we're talking to attorney David Bizarre. You're also a mediator as well.
That's correct.
Not all mediators need to be attorneys, is that correct?
That is true.
They have different training.
Right.
Do they need to know the law?
Well, not necessarily, but I think it's helpful, and it's helpful in certain situations. One of the things as mediators we have to be careful of and watch for is to make sure that there's not overreaching. And so if the two parties aren't in equal bargaining positions, there can be some concern that one party will take advantage of the other party. And that's one thing we as mediators cannot allow. So it's important to know the law in that sense, so that if you see one side overreaching and the other side acquiescing, you can say, make sure that they understand you're allowed to give away the farm, as one mediator instructor once told me, as long as you understand what the farm is. So you can give up more than you would otherwise be entitled to, but you need to make sure as a mediator they understand what they're entitled to, so that it's a knowing giveaway, so to speak, not just something that, oh, I didn't know I was entitled to more. So to that degree, you should know the law. And as far as not needing to be an attorney, oftentimes it's advantageous that, depending on what is being mediated, that the mediator not necessarily be an attorney, and that it's not the law that's involved, but some other facts and so forth. So in divorce mediation, oftentimes a lawyer might partner, because you said just one mediator. You might have two mediators. You might partner with a financial planner, or you might partner with someone who's got some training in child behavior, in psychology, to help divide up time with the children in such a way that is beneficial to the child, that type of thing.
Now, would you, if you were a mediator, be the one to say, I think we should bring in a financial advisor, we should bring in a child psychologist? Would you be the person who would suggest that, or would one of the parties that's coming to you for the mediation process?
I will often suggest it either as we could bring in another person to help mediate this issue, or if you guys and gals are getting close to a decision, but I'm concerned that maybe there's some issues they need to know about, I would tell them, go speak to a financial advisor, or go speak to a psychologist, or somebody who's adept in children's issues, if I think there's an issue that they're not really looking at and I want them to explore further.
You bring up an interesting point, because I was going to ask, if someone is going to look for a mediator, yes, you can, not the yellow pages, someone's going to Google them, and there's an association from which you can select. I imagine the courts can do the same, have a list or a roster. If you're looking to find the right mediator for you and your situation, how would you go about doing that? Would you just call and ask, how experienced are you in, I don't know if we said divorce mediation, but maybe it's an employee-employer situation. How do you ferret out who the best mediator is? How do you select? What's the process?
Well, like being referred to an attorney, I think word of mouth is the
Sure.
first place to go. So if you have a friend or somebody you know who's been through this process, ask them what their experience was like, and if they would refer people to the person they used. That's one place. There are, as you said, associations you could contact. The court, at least family court in Rhode Island used to, I'm not sure if they still do, they used to maintain a list of mediators. And the family court might not anymore, because they actually have their own mediation unit, which is free for cases that are brought already to family court. Some cases are automatically referred to mediation. Others,
Why?
Well, if you're not married and you have a case that you brought, which we would call a miscellaneous petition, there's a court order in Rhode Island Family Court that says all miscellaneous petitions need to go to mediation before the judge can decide them.
Good to know. I would think that in the mediation process that there's always a concern that if you, not you specifically, but you as a mediator, didn't have enough of a frame of reference, how would I know, as the party coming to you, whether or not you would overvalue, undervalue something? So the fact that you bring up the point that you could actually bring in another person to help make sure that the assessment or evaluation is done properly certainly makes a lot of sense. Now, would the courts also do that if they have a mandated mediation? Would they also say, and bring in a financial person too, or no?
No, they don't do that.
They don't do that.
No. And usually the ones that are required to go through mediation are about children, custody, and visitation. And
Okay.
so these mediators that work for the court do that all day long. So they know those issues. They may be adept at knowing some of the financial issues. They may not. So divorces that go through the family court mediation program know more sometimes, I think, about the financial aspect of things. And so we will actually, I don't want to really use the word educate, but I can't think of a better word, educate the mediator on some of the factors that are going into the evaluation of assets and how we're proposing the division of assets may be. Now, the two lawyers may not agree on what the division is, but once the mediator has been brought up to speed, that's a better way to phrase it, on what the assets are and how they're valued. If the two lawyers can agree, then the mediator can weigh in on how to divide those assets.
I know when we've talked about mediation in the past, it's been clear that it requires discussion, communication, and people, I think, probably work best if they're doing it voluntarily. If it's mandated, it may not be so voluntary and so kind and so reciprocal and open. And so can you actually mediate something if there is a very contentious and adversarial situation to start with? Can you usually work through that, or is it impossible? Or?
A good mediator can,
yes?
But here's the thing, as you're saying. So in divorce, for example, what we'll often tell people who are coming in to talk about mediation is to explain the process. And one of the things we'll explain is the advantage of mediation is that, first of all, the two parties are going to decide the outcome, not some judge who doesn't know them. The second thing about it is it requires communication. And oftentimes a good mediator will make the two parties speak to each other, and oftentimes in such a way that they haven't spoken to each other in a long time, which is part of the reason they're there. And so one of the outcomes can be that they may re-engage with each other in a way to communicate that will really support and help their issues down the road after the divorce, when they still need to communicate with each other, especially about children. And so that's another thing that can come out of a good mediation. And of course, the final thing, which we say in all mediations, not just family court, but is you'll save time and money and have a better result usually.
So that sounds so good, but if someone's already retained lawyers, once they've already had to put some money down for that, would it still be a savings if they had mediation? I imagine that it might maybe take some of the pressure off if you have a mediator. So might that be the way that they would save time and money?
Sure,
That's
because you're saving the time and the money from a contested trial. And it's at the point that you get to a contested trial, and I know we've been talking about family court and divorces, but it applies to superior court and personal injury litigation, superior court and litigation between owners of a business. All of these things can be subject to mediation. So avoiding the trial, which is the uncertainty and the expense, applies to all of those things.
And we're speaking about the family court situation, but mediation can be used for businesses too. What other kinds of mediation cases do you see on the rise or just on the horizon?
So we do a lot of mediation for personal injury cases. And those kinds of cases where there's either a lot of damages but questionable liability, or other issues that aren't sort of, I would call the run-of-the-mill type of personal injury cases, mediation can be very helpful. Medical malpractice cases. Any case where there's some difficulty in proving the case, or in the damages are so big, mediation can be very helpful in those types of cases, and we're doing a lot of those right now.
Interesting. So the other side, or not the other side, but the other technique, arbitration, not always one person, could be one from one side, one from another, and a third that's in the middle. How does that play out? Is that, I understand that's more of a formal process. Is that, can be more costly? Are you saving money that way versus going through litigation, or is that debatable?
You'll save money.
Yes.
Because it is less formal, and therefore it is an easier case in some ways to present to the panel. You're right, it can be either one arbitrator, it can be two arbitrators with a neutral arbitrator. We call that a three-panel arbitration. There are other forms that it could take, but the expense of presenting that case to the panel is much less than the expense of trying that case. And the reason is it's a streamlined process. And if it's a personal injury case, for example, the arbitrators don't need, usually, for the parties to bring in the doctors to testify to the damages, or the expert on the defense side to testify to the lack of damages, or any of those things. They can usually be brought in by the reports and affidavits or whatever from the doctor. So you save a lot of time, the attorney's time, in trying a case, because when you're presenting live witnesses like that, it takes a lot of time, and the expense of paying those expert witnesses for coming in. So it's usually much less expensive to do it that way than to try the case. And it's to usually attorneys who have experience in the area. So the outcome is a little more predictable than trying that case to a jury, which with any jury, you never know what it is going to be that sways a jury one way or another into whatever their outcome might be.
So we haven't talked about binding versus non-binding arbitration, but to your point about personal injury cases, who decides, and how is it decided whether it could actually be something that could be mediated versus going to arbitration? Who makes that decision?
The attorney's handling the case, usually.
They do.
And by agreement. So if you're in Superior Court in Rhode Island, and you have a case that's going through the process, the judicial process for litigation, that case, generally speaking, has to be arbitrated through the Rhode Island Superior Court arbitration program. And that program, the two lawyers can either select by agreement an arbitrator, or if they don't and they submit it to arbitration, certify that it's ready for arbitration, they'll get a list of 5 arbitrators from the arbitration panel. That panel will be sent from the court's arbitration office. And they each get to strike 2. So if they both strike 2 different names, the surviving name is the one that's going to be the arbitrator that's appointed by the court. And so, again, it's a requirement for most cases. Certainly cases that have a value of less than $100,000 have to go through that process. Once it's put into the arbitrator's hand, there's a time frame for the parties to get all the information to the arbitrator, for the arbitrator to hear the case, and for the arbitrator to render a decision. So there's a fee. I think, I've forgotten, but I think each party pays $100 initially to submit it to the arbitration program. And then if a party rejects it, I think there's a rejection fee of like $200, or if the award that's given is accepted, they pay each pays a lower amount. So that process is fairly inexpensive, and it's not binding. We talked about binding versus not binding, because either party has the right to reject the court-appointed arbitrator's award and have a trial on the merits de novo, meaning from the beginning, as if that never happened.
Rather than it being an appeal, it's considered...
Not an appeal, it's a trial de novo.
No.
And you have the right to go back and have the jury hear the case.
Good. Could a mediator be an arbitrator?
Yes.
Does an arbitrator have to have more and different information than a mediator?
So, and can a mediator be an arbitrator? Yes, as long as the mediator, for example, in that Superior Court arbitration program, is a lawyer, because you have to be a lawyer for more than 5 years to get appointed to that panel. There are other forms of arbitration where the arbitrator does not have to be a lawyer, just for that. And the two things can both happen in the same case, because you asked who picks. Well, you can pick a mediation first, for example. And remember, a mediation isn't binding. Both parties can say no. There are probably some forms of binding mediation or something that, it's really binding arbitration. I'm thinking outside of the court setting for labor relation kind of things.
Yes.
But I think those are usually arbitrations. This mediation that you pick from a court case that's in litigation goes through, you do your best, you try, the mediator tells you why you should settle it, and there's a lot of techniques we use where we may say to both sides, give us a range where you definitely will accept an award, might accept an award, definitely won't accept an award, and we'll try to see if there's a number in there that neither side knows what it is, where both sides would overlap. A lot of different things we can use to try to get it to a point where there's a number we know that they'll accept and we can get the case settled. But it doesn't always work. And so if a case goes through mediation and doesn't work, and it's one of those Superior Court cases where arbitration is required, now it's going to go through arbitration. And if it's not a binding arbitration or it's a court annex binding arbitration, then if either side doesn't like it, they can appeal from that. And then it'll end up back in front of the court and end up in a jury trial.
Is it true that by the time you are dealing with arbitration that you should have a lawyer on your side to make sure that your case, your side, is presented as succinctly and as cohesively and as tightly as you possibly could have it, or does it not matter?
Well, if it's a case that's coming through the court that's already in suit, you should have a lawyer before it's put in suit, because you really don't want to be representing yourself in the court system for a possible trial without having an attorney. So yes, you should have an attorney. If it's one of the other forms of arbitration that may come from a consumer agreement that says the parties have to go to arbitration, or a labor dispute that requires arbitration, or that type of thing, you don't necessarily need a lawyer for that.
And talking about compelling, is it true that courts can compel mediation? They can also compel arbitration? Can they do both?
Yes, and they can. In federal court, the alternative dispute resolution is required. The attorneys usually get to pick what form they want to use. If you have a case in Superior Court, like I said, in Rhode Island, arbitration is required. The court generally won't require parties to go to mediation, but they may strongly suggest it.
So interestingly, we've not spoken about, we've talked about estates and trusts before, but not in this particular context. I was reading that in California, when it came to the settlement of a trust, that the court had compelled mediation to take place for a disputed trust. And I guess it's also being challenged. So it seems that while that would make sense if it could happen that way, mediation seeming to be potentially amicable rather than terribly adversarial, do you think that that parties should be forced to do mediation when there's such a dispute about something like a will or a trust?
So two things. Just to go back to, can the court compel it? The Rhode Island Supreme Court also has a mediation program for cases that are on appeal to the Supreme Court. So they can compel it because it's part of their rules. If there are no court rules that gives the court the authority to require either alternative dispute resolution, being arbitration or mediation specifically, then I'm not sure that the court can require it. And even if they do require it, what does it really mean if the one party is going without the desire to be there and the willingness to meaningfully participate in that mediation, because it's not binding? So going back to the case that you brought up where there's a trust in the state, it's usually probably a dispute about the will, so it's a settlement of the, a probate of the will, or a trust dispute, which might be in Superior Court litigation. Just like any other litigation, the same rules apply. So if the court has authority to require mediation, the parties should go. If they don't, the court should suggest to them why they should go, and really, I think most parties, if they go with an open mind, would understand why there's a benefit to going through mediation or arbitration. And I would want to go through it if the court suggested it to me, because I don't want to go back to the court and be the one who said, nah, I didn't want to go there in the first place, you made me go, I had no interest, I didn't participate. I don't think the court's going to look too favorably on you under those circumstances.
Good point. So earlier we mentioned that there's an increase in the ADR technique. Not surprisingly, as I was just doing some research here, that because of COVID, there are more people who are having difficulty paying their rent. And landlord and tenant disputes are on the rise because the tenants are unable to pay. So while there was a banner that was keeping people from being evicted, soon that in some states, New Hampshire being one, it's about to be lifted. So the thought in the enlightened state of New Hampshire is that they're going to bring that kind of a dispute to mediation. comment on that? Does that make sense?
Yeah.
How could it work?
Well, it can, and back in the beginning days of the pandemic, before, when the ban was starting to be potentially lifted in Rhode Island, I had some conversations with the district court and when I was president of the Bar Association about creating a panel of lawyers to advise and assist tenants because usually the landlord already had an attorney in the process. And there was also, remember, there was the funding from the CARE Act and all that.
Right.
There was some money available for states if they wanted to use it for that, to put towards helping in these eviction cases, having some rent available from a fund. So there was something to actually mediate. You as the landlord, would you accept, all right, they're 4 months behind. If we can fund 2 months for the tenant, and you as the tenant, can you agree to a little extra payment on your rent going forward and paying your rent to pay the other 2 months over time as a way of keeping someone in the home and getting the landlord paid maybe over time? So there were things that could be mediated. So there is a reason for mediation in those cases, especially if under the new bill that may come out someday, there's money available to help with evictions and funding some of the back due rent.
That certainly sounds like a very reasonable approach to come to an agreement. It's something that is win-win.
Right.
That's very encouraging, David.
Yeah, and we don't know what's in, well, I don't know what's in the proposal for the new package, but if there is money available and it can be used, I think one of the key areas to keep the economy, and this is all about the economy, these budgets, that they're proposing for packages to come out, to stimulus packages or whatever they're calling them. If it includes money for homeowners and for tenants to be able to either catch up mortgages or pay back due rent and come to some kind of compromise so that the landlord is going to get compensated and the tenant might not get evicted, I think that's, as you said, a win-win for the economy.
It certainly sounds like it is. In states like New Hampshire and Maine, they certainly have been issuing a mandate that said you cannot evict a tenant, especially if it's winter and it's cold, and there are certainly some serious parameters that you really can't evict. So this seems like such a reasonable approach, and I hope that that goes a long way to helping more states, even if they aren't in that situation, be much more reasonable.
Yeah, well, you've got two sides to that equation, and you've got the people who need a place to live, but you also have the landlords who need to pay their mortgage and pay their expenses. So if there's a way of bridging that gap and getting everybody something, it'll be very helpful.
Terrific. We hope that this conversation's been helpful to you in mediation and arbitration. We hope you'll continue to stay tuned to the Law Matters as we tell you the law matters to you. Thank you for tuning in.